Welcome back to Adalat. I have two special guests in the studio today, Anthony Okuma and Gurpreet Chadha. Both of them are solicitors and they've been giving us some very useful information about general civil law and immigration. And we've also talked about housing and landlord and tenant. And I was wondering if in this last segment we could talk a little bit about landlords and immigration. Anthony, is there any further information you can give?
Of course. The law gets more complex.
Yes.
Landlords now have a duty to check from April 2016 to become essentially the Home Office, as it were, to check the status of any tenant who is renting a property from them.
The immigration status.
The immigration status. Now, ask me how they're going to do it. Just double check that the person, the tenant, has the right to reside in the UK, or it's a member of the EEA, which means the European Union, in order for the tenant to be given the accommodation. If a landlord doesn't comply with that, they will be penalized.
Really?
So
to what effect?
To the effect that they will get a fine.
How much?
I'm not clear on their level.
It's thousands, isn't it?
It is about in the region of 2,500 or so.
Yeah, it's something.
So in effect, landlord has another administrative task to deal with, in the sense that they have to check the immigration status of tenants.
And again, is this for ongoing tenants as well?
It starts from April 2016.
So when it starts, does that mean that every landlord will have to look at existing tenants too, or is it just for new tenants?
I think it will be advisable for any landlord to check the status of their tenant from April 2016 in order not to run foul of this particular regulation. I think it's quite draconian for landlords to take on the work of the Home Office, but it is what it is, and I think landlords should be prepared for these changes coming into effect.
Right, that always brings me to the grey areas, Anthony. Of course, there will be people who may not have status, but they will have applications in the Home Office. And we all know how long the Home Office takes to decide applications, so they'll be ongoing. What would be the status of those people?
I think my colleague will be able to clarify, but what I understand is if you make an application, you will get a letter from the Home Office confirming that you've lodged an application and your status remains the same until the application is hopefully decided.
Right.
So on that basis, then the tenants could be, of course, some landlords will not be satisfied, which brings into that grey area, and they might want to evict the tenants purely because of the Home Office not doing their work properly. But in that instance, I would suspect that the tenant will have the right to rent the property or still stay in the property, because there is a letter from the Home Office to confirm their status until the decision is made on the application.
Okay, Gurpreet, can you add anything to that?
Yeah, I think that's where the technicalities and nitty-gritties of the law comes into a picture. Now, as Anthony's pointing out, that yes, landlord has to satisfy that the tenant has got some sort of a legal status in the United Kingdom when he's offering accommodation. Now, from the immigration perspective, a tenant may be having, at the time when he's taking the premises on rent, he may be having some sort of a leave.
Yes.
Now, but by the time during the duration of the tenancy, the leave is expiring.
Yes, of course.
Now, at that time, it's very important for the tenant. I'm talking about the applicant's point of view, who's an immigrant and who's got an immigration application.
And who may have family and little children and so on.
Yeah, because obviously during the term of the tenancy, if the tenant runs out of his leave, the landlord is also facing a draconian legislation that he has to be satisfied that tenant has got some sort of a status in the United Kingdom. So which means that tenant has to be extra vigilant now that the application for leave to remain, which he is making for extension, should be made in time. Yes. And he should always be careful that he is making an application before the expiry of his leave.
Yeah.
And when he's making that application before the expiry of his leave through any legal experts, then yes, Anthony's right that you may get some sort of a correspondence from Home Office saying, acknowledging that yes, your application has been received. That's one thing. And obviously, I think it's always good to have a letter from your legal representative referring to the relevant legal provisions that, okay, well, if the application has been filed before the expiry, then the leave will be considered as an extended period of stay until the application is decided.
Of course.
So it's both for the tenant and for the landlord, for their peace of mind, that they are actually complying the rules and regulations. So I think this is quite important that they should understand that.
Right. Any other information you can give about landlord, tenant, and immigration? Because then we can move on to another area.
One thing I think we have, this must have been discussed earlier as well, and that is landlord, tenant. It is all linked to the immigration, because obviously the Home Office is coming with these strict provisions that if, and also in the recent decisions which are being made on your asylum cases or immigration cases, they send a letter along with that where they try to highlight this to the applicant that yes, if your case is refused, then these are the things which you can face, which is that you may not be allowed to work, you may not be able to get the health benefits from the primary care, and you may not be able to get the accommodation from the landlord, because the landlords are under legal obligation to carry out these checks. And above all, they also talk about that you are not allowed to work in this country, which means that if any employer employs an illegal person, then he can face a fine to the tune of up to £20,000, which is a quite a lot.
£20,000 for
as
employees.
up to £20,000 the fine can be imposed. So which means that it's like employer has to be very careful while employing any person who's on leave to remain in the UK.
I mean, what sort of evidence should employers look for when they advertise jobs? And when people apply, what should they look for? Anthony, can you give some?
I think the employer should definitely be satisfied that the prospective employee has the right to reside and work in the United Kingdom before they make an offer of employment.
And how can they ensure that?
By looking at their passports.
Well, what if the passport's in the Home Office for a renewal or something?
Then that's the grey area, because the employer may, I do know that the employer could ring up the Home Office. There's a dedicated telephone line for employers to check the status of the prospective employee. My feedback is that that line is not answered promptly, which is not surprising, if I may say, for Home Office. But the employer can actually make that call to obtain the necessary confirmation that
that's very useful information, because I know a lot of people apply for jobs and they can't provide everything that the employer wants. But if they can actually check directly, that's the best information. And do they always get correct information?
That's another issue with Home Office, which I think one will have to bear in mind. But at least is to make that attempt, and touching on the landlords, because the issue is whether the landlords have the opportunity to ring up to double check whether the prospective tenant has a right to reside in the UK. I don't have the particular information as to whether they can make that call, but my advice to any landlord will be to keep a record of any documents that you've seen which confirms that your tenant had the right to reside, and constantly monitor, essentially become the Home Office when that right to reside expires. Because you can have a tenant who had the right to reside, like my colleague pointed out, but in the course of, say, a year or two, that leave to remain, as it were, runs out without the tenant applying for that. It's really on the landlord to keep a record and make sure at the expiry of that leave to remain that they make inquiries of the tenant as to whether or not they've lodged an application for an extended, an extension or further leave to remain in the country. If not, the landlord will run foul of the legislation and will face a fine.
Okay, well, can I put a question to both of you?
Yeah, sure.
What do you think is the purpose of all these strict changes in the law? I'd like you to answer one by one.
I would say it's cost saving, really. It's in simple terms. Home Office are really pushing their responsibilities down the line to the landlords and the employers, so that cost will be saved by that administrative task is dealt by someone else as opposed to the Home Office. That's my view. And
Gurpreet?
but I'm sure
I agree with Anthony, actually. That's cost, and also I think they're passing on these responsibilities now at the grassroots level, where they want people actually to report if there is anything, if there is any immigrant who is not complying with the immigration rules. So, and I think it's a cost-saving effect is definitely
Indeed.
there.
And if I may digress, I think I also feel that it will, with people within the ethnic minority community, will also have a bit of difficulty, because some landlords may choose not to rent their properties because if they have a feeling that you may be a migrant, legal or otherwise, but they don't want to be encumbered with this rule of checking, then some may well decide not to rent to people who they deem may not have the right to reside in the UK. And that to me could be some form of discrimination, which of course you can bring a claim, but it's a grey area. I think
That would be quite difficult to prove if you and the landlord are the same ethnicity, though, wouldn't it?
it may or may not. I mean, I wouldn't say I'm an expert on discrimination, but I can see the problems arising, because landlords may well choose not to rent out to tenants who they feel are from a different, perhaps from migrants that moved to the UK, whether they have the legal status or not. Generally feel, well, I don't want to be encumbered with making these checks. I'd rather rent to someone who I can see a birth certificate was born down in Slough. You know, it makes life easy. So I can see how that will cause a lot of problem. And it's really interesting. We'll obviously keep an eye on this, and if there's issues arising, then we'll have to check whether we can bring a claim for discrimination.
I think there's also a deeper reason. You've both identified very important reasons, but I think there is a deeper reason, which is to send a message to the rest of the world that Britain is not a soft touch, because Britain feels that it has been seen as a soft touch by the rest of the world, and people have just flocked here, which to some extent is true, but not entirely. There are reasons why people have come here. The whole world is in a state of unrest at the moment. There's war everywhere. And some of that war has been interfered with by the West. And I don't want to get too political on this show. I prefer to keep it a legal show and a fact-giving show. But if we have some time left, I would like to touch on the entrepreneur position at the moment, because I know there are a lot of our viewers who are entrepreneurs. So Gurpreet, can you give any current information about the status of entrepreneurs?
Yeah, I mean, entrepreneur category, tier 1 entrepreneur category is available to those people who want to be in the UK with an investment funds of up to, there are different categories, like where they can investment funds up to 50,000, and then there's investment funds up to 200,000. So if anybody wants to apply under the entrepreneur category, they have to show that yes, there's those 50,000 investment funds are available to them. And then with those funds they can, once they demonstrate that, and they are also able to show that they have maintenance accommodation, then they can apply under this category.
Right. And are the rest of the provisions still the same?
Yeah, quite of them are similar to that.
I've been told that we have come to the end of the show, and I've just got enough time to say thank you, Anthony, so much. And you are our first new guest. On this show, we bring new guests every year, throughout the year. And welcome to Adalat. I hope you will come again.
Thank you.
And Gurpreet, thank you very much for coming, and thank you for bringing Anthony, who's given our viewers such useful information. It was a pleasure.
Thank you very much.
Thank you for watching the show. We shall meet again next week, hopefully. Until then, look after yourself. The whole of the Adalat team says good night and goodbye.